you're concerned. You're thinking Obama and Hillary are trying to rewrite the 1964 Civil Rights Act. Give us more on this.
Well, this all stems from the famous or infamous, depending on your point of view, HB 2, which is the law in North Carolina, which says that in public facilities, including universities and public schools and, roadside rests and so forth, that the restrooms and the showers and so forth will be assigned to people based on their biological sex. Now, that, of course, is a famous law. What the Civil Rights Act has to do with it is that the Obama Department of Justice has sued North Carolina claiming that this law violates both the Civil Rights Act and the 1972 Education Act amendments, which is Title IX. That's the famous law that says, that women should have the same access to sports and college, and it's pretty well known. So
right,
there's also a third act. Yeah, there's also a third act from 2013, which I'm discussing less basically because it's less irrelevant. But the first two, those two very famous Civil Rights Acts, the Department of Justice is claiming says you cannot have a law that says you assign bathrooms and showers by sex, biological sex. Well, those laws just don't say that. And so the problem that we're facing is that we have the executive branch saying that it can rewrite two very, very prominent laws, although it really doesn't matter if they're prominent, to say whatever they want them to say and then go to court based on that. And what we're saying is, no, you can't do that. The separation of powers says Congress decides who passes laws, not the White House. So if you want to do this, you either convince Congress to change those laws, or you convince North Carolina to change its law, but you don't just get to say, as Barack Obama or as the Department of Justice, that the Civil Rights Act and the Education Act amendments say something they never said.